Howdy, my name's Brian Foley. I'm a criminal defense attorney here in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, Houston, that general area, and sometimes all over Texas. But today we're here to continue our Rules of Evidence series. Our last rule was Rule 204, so you might be thinking that today's rule would be 205. Well, there is no 205. So maybe you're thinking, okay, well, that was it for the 200 series. Now we'll be in the 300 series. Well, 300 series rules are about presumptions, and they're only in the federal rules. They're not in Texas. We don't have any 300 rules. So today's rule is going to be 401 and 402. And I'm combining those two because they really kind of work together. Rule 401 describes what is relevant evidence. So relevancy. You ever heard objection relevance? That's really an objection under 401. And then 402 states kind of more clearly that relevant evidence is going to be admissible unless there's some other rule that, in the rules of evidence that says it's not. Let's take, for example, Rule 403 saying, although it's very relevant, it's so relevant that it's prejudicial. And it's a little more nuanced than that. We'll go over that next time when we go over Rule 403. But 402 says, unless there's some other rule that says it's inadmissible, then it is admissible. But if it's irrelevant, if it does not meet the standards of 401 for relevancy, which are pretty low, then it's not admissible. And that's what Rule 402 says. So let's talk about the rules of evidence. 401, this is one of the most hotly contested rules that we have. Objection relevance is happening a lot. A lot of times it's going to be overruled. There is so much that is relevant. It doesn't have to be the whole wall. It can just be a brick that builds a wall, right? That was what I learned in law school from my law professor, was when you're talking about whether something's relevant or not, it really is just, does it make any fact of consequence more or less likely because of this evidence? So for example, it might not matter that you had an argument with your neighbor the day before you got into a car accident, unless the car accident was with your neighbor, and maybe there was evidence that the neighbor intentionally hit your car as opposed to by accident, right? That argument would show maybe a possible motive as to why you're having this issue with the neighbor. It would show, it could be relevant in that circumstance. But if you had an argument with your neighbor 2 years ago and you got in a motor vehicle accident with somebody else later on, just proving that you've been in an argument before doesn't really help. It really doesn't make any fact of consequence more or less likely in a new case involving different people. Let's see, what else we got here? Oh, yes. Okay. Witness credibility and bias. That is almost always relevant. Really always. I mean, not almost always. It is always relevant. Background information of a witness may also be relevant. For example, like background training for a police officer, or maybe lack of training for a police officer. There's a case on this called Valencia versus State, 891 Southwest 2nd, 652, for all my lawyer friends out there. Now, there's other types of evidence that have been ruled to be relevant. Lots of it, right? Every case that has evidence, things get ruled to be relevant. So like firearms that are found on scene, blood spatter, photos, and potentially expert witness testimony. That's going to be covered a little more in the Rule 700 series. But here's some stuff that's been ruled relevant. Consciousness of guilt evidence. So when a defendant has done something or has been alleged to have done something, and then later on they act in a strange way that shows maybe they feel bad about what they've done, that they're conscious of the guilt that they hold. So that could look like showing up to the crime scene, of a place where they have no other real reason to be at that place other than a crime had taken place there. Another one is attempts to conceal or destroy evidence. Although it's not relevant to whether or not somebody actually committed the offense, like beforehand, right? This evidence of something that happened afterwards could tend to show that somebody had engaged in some illegal conduct if they're trying to destroy the evidence. So that regularly gets admitted. Flight from the scene of the crime has been ruled to be relevant. Witness tampering, trying to coax a witness into not engaging in some matter, that's been ruled to be relevant. And failure to identify yourself to police has also been ruled to be relevant. Here's a good example of something where the relevancy objection has really, held firm, and that is in a DWI third. Okay, when you have a DWI third or more, that's a felony, and so the reason it's a felony is because you've got 2 prior convictions for DWI. Well, if you do not stipulate to those prior convictions, then the prosecutor is going to have to prove them in the guilt innocence phase in order to prove that he has jurisdiction to try you in a district court. Well, what might the prosecutor do? Well, he could enter in a judgment, and that wouldn't be too exciting. But what else he could do is he could call the police officer from the original case. He could get them to testify about what it was. If it was a car wreck case, somebody got injured, they could call the victim from the prior case just to prove up the fact that there was a DWI previously. But under a case called Martin versus State, if the defense stipulates to the 2 prior convictions, then it becomes irrelevant. All those details surrounding the prior DWIs. The fact that they've been proven is stipulated to by the parties, and it removes that burden of proof from the prosecutor as far as the jurisdictional elements. Now, the jury's still going to hear that there were 2 prior convictions, but they're not going to hear anything else about that. And so that can be a good strategy if you really don't have a good defense to the prior 2 convictions. But oftentimes, especially if you're maybe a 25 to life punishment range because of 2 other prior convictions, you may just want to have the strategy of contesting everything, making them prove it from top to bottom. So that's a little bit about relevancy. The only other thing I can think of that's relevant here would be what's called the standard of review. And the standard of review is an abuse of discretion, right? So a trial judge has broad discretion to rule on evidentiary matters, on relevancy and things like that. And so because the courts have found that reasonable minds may disagree about the inferences that you can make about whether a certain piece of evidence is relevant, they leave it up to this zone of reasonable disagreement in an abuse of discretion standard. And for all my lawyer friends out there, you can look up Montgomery versus State, 810 Southwest 2nd, 372. That's from the Texas Court of Criminal Appeals back in 1990, and it's still the law today. So thanks for tuning in. That was Rules 401 and 402. And don't forget to click the like button if that was helpful to you. Don't forget to click subscribe to get all my other content. And thanks for watching.